SJC-11568, Commonwealth v. Joseph Sullivan.
Good morning, Your Honor. Kevin Curtin, Assistant District Attorney for Middlesex on behalf of the Commonwealth. With me is Assistant District Attorney Nicola Lane, who is the trial prosecutor. We're here on the court's grant of further appellate review on the Commonwealth's application for further appellate review on the accosting conviction. Because the defendant's conduct constituted offensive and disorderly conduct within the meaning of the statute, the court should affirm. In Cahill and Chow, this court fairly recently taught that to prove accosting, the Commonwealth must prove that the defendant's behavior was offensive and disorderly to a reasonable person.
Offensive and what, excuse me?
The issue, sorry, Your Honor?
Offensive and what?
And disorderly. Offensive and disorderly to a reasonable person. And the issue here is the sufficiency of the evidence under Lattimore. The evidence was sufficient to establish that the defendant's conduct was offensive. The court in Cahill said that acts that cause displeasure, anger, or resentment, especially those that are repugnant to the prevailing sense of what is decent or moral, can be offensive. We're talking about morally offensive. That's different from physically offensive, which is one of the ways to prove disorderly under the second prong. And that was the theory under which the judge put the case to the jury here. And the court in Cahill, quoting Commonwealth versus Peace Chow, has taught that acts that create a physically offensive condition for no legitimate purpose of the actor can constitute disorderly acts by reason of having created a physically offensive condition. Two different things, offensive morally and physically offensive condition. There was ample evidence of both in this case.
But the legislature here chose to limit this to persons of the opposite sex. So what meaning do we give to that?
Well, it has to do, that is a phrase that speaks to the gender of the defendant and the victim. It does not speak to the content of any communications, let alone the sexiness of any communications.
Why have it if it doesn't have something to do with, I mean, doesn't it suggest that there is some sexual interchange going on?
And the legislature has now defined this as a sexual offense under 123A Section 1.
Yes. So two things there. I think that, first of all, nobody's complaining that this is, nobody's raising an equal protection issue here for want of equal protection. It should be struck down. It's rationally related, one imagines, to gender differences as we understand them in our society. And here there's no question that he accosted her, confronted her because of her gender. So there was sufficient evidence of that. And that probably is as far as we need to go on that issue in this case.
The statute's really old, isn't it? I mean, does this go way, way, way back?
It goes way, way back, as the court in Chow discussed, and in 1947 discussed also in Lombard. But recently, we've been paring away, and I'm going to come back to Your Honor's question, to comport with constitutional requirements and other considerations. For instance, in 2009, the disorderly person conduct was set apart to allow for a lesser offense on that particular charge. Disturbing the peace now is not a 6-month maximum. It's $150 for a first offense. And in the course of doing that, the common railers and brawlers provision was taken out, but otherwise the rest of the provisions significantly reduced from what it used to be in the early days remain. Now, with respect to the question of the fact that accosting can be a predicate offense, or is a predicate offense that allows the Commonwealth to petition for a sexually dangerous person, I have no problem with that. And I think that the court should have no problem with that either. It simply allows the Commonwealth to go forward on a case. And certainly, in a case like this, given this defendant's record, which is in the record, the fact that what we're talking about is abducting a little girl, as he viewed it, from the streets, there's nothing wrong with allowing the Commonwealth to go forward and try to prove that he's a sexually dangerous person. It doesn't mean that there needs to be sexually explicit conduct
Okay,
to
doesn't-
prove.
Well,
There's
what
a need-
about sexually implicit conduct? That's your position, isn't it?
Sexually implicit conduct would certainly count, but one can imagine, although it might be hard to imagine, morally offensive conduct that doesn't necessarily imply sex. It could be, for instance, someone going up and urinating in front of a person. That may not connote sex. There may not be a display of genital organs, but that might very well be viewed by a juror as offensive, morally offensive, contrary to prevailing moral.
So you're saying,
values.
so you're saying there can be a violation of 53A without there being anything sexual about it?
I think that, yes.
And then do we need to then declare do we need to declare that provision which to characterize it as a sexual offense to be unconstitutional because it's characterizing as a sexual offense that which may not be sexual?
No, not in this case certainly, and not in the next case necessarily either. Because in that case, if there's a case in which a juror or judge finds a person sexually dangerous solely on the basis of an accosting conviction in which there was no sexual conduct or no sexual motivation, then that would raise an issue as to the sufficiency of the evidence of sexually dangerous person.
Okay, there's another way to look at that, though, and that is that by including the definition of annoying and accosting, by including annoying and accosting in Chapter 123A, the legislature did intend to cabin a Section 53 offense by making it a sexually oriented offense as opposed to simply morally offensive.
Well, I think the better view is that those amendments had to do with the disturbers of the peace, $150 change. And there's nothing that I found, and nothing that's been suggested to the court, indication that by making those changes, they wanted to add an element to the charge of accosting. There's no need to do that in any event, because we already have, as the judge charged, and as they're included in the model instructions, the contrary to the prevailing moral standards, the normative standard. We already have that. So moral offense under the first prong, plus physical offense in this case, or other things such as threatening, which could have happened. I mean, the judge could have let it go to the jury on threatening, and which is, but the judge didn't, because you don't have to have explicit threats, as we know under the language of Chow, to constitute threats. So there's really no need. And here, even if the court were inclined to say that we're going to now say that there has to be sexually implicit to make out accosting for the reasons that the defendant is advancing, there's ample evidence here of that. It just is a matter of common sense and what was going on here.
What's the evidence?
Well, come here, little girl. Come here, I want to talk with you. The defendant has 2 encounters where he speaks to her, and in this tone of voice that was so striking, this sugary sweet.
Don't you think that gets a little bit subjective when we're talking about tone of voice and sugary sweet?
It is. It's
I mean, one person hears sugary sweet, another might hear vinegary, you know.
That's absolutely right, Your Honor. And that's why it's important to have these facts go as factors to whether it constitutes offense, just rather than litmus tests. For instance, you could have a litmus test that there must be sexually explicit language. So that's too narrow.
I'm troubled if the thought is we might be sending people to jail based on the tone of their voice.
Well,
You'd have to admit
there's
that
no
would
question
be a problem, wouldn't it?
that is not permissible, because it has to be disorderly, as defined, as well as offensive. So there is no way that a jury could convict simply on the basis of either the content of expression or on the basis of the tone of voice. It would have to be physically offensive, it would have to be disorderly, have to amount to disorderly, and as the court has construed that provision of the statute, and in Chow said that it applies to annoying and accosting as well under the second prong, that using the model penal code's definition, there are not any constitutional issues that are raised thereby, because it's not just tone of voice, it's not just expressive. However, it's a factor for the jury to consider, like you're trying to bribe somebody.
If we agree with the defendant, at least in part, and we have to decide whether or not there was a substantial risk of a miscarriage of justice and an element was not presented to the jury, what do we do about the fact that the defense here was misidentification? Was there also any defense in this case that
There
went?
was, I'm sorry.
It was a mixed defense.
Yes, the misidentification was the principal defense. That was the principal focus of the motion for new trial as well. However, in the defendant's closing, he said this isn't even a crime. And in fairness, it was a number of different theories. In addition to that, the defendant also argued, tried to make a Bowden argument, and argue the victim's credibility as well. So it's not just misidentification, but that doesn't harm the Commonwealth, because the Commonwealth needs to prove the case anyway.
But I mean, if some measure of sexual conduct, or at least proof that the victim here had a reasonable fear of a sexual assault is required, and the jury wasn't told that, how do we affirm?
Well, you don't have to have a reasonable fear of sexual assault under the accosting statute. Now, your fear is an important factor for threatening, for instance. The victim's fear that she's imminently about to be assaulted, even in the absence of an explicit threat to assault, a true threat, as recently has been repeated by the court, quoting Chow, a true threat does not have to be explicit if the victim feels that she's immediately about to be assaulted. But you don't need to have immediately about to be assaulted under accosting. You can have that under assault with intent to commit rape. This is something less than that.
Okay, but let's assume that you're not persuasive to us, okay? Let's assume that we do conclude that there is some sexual conduct, and let's assume that your best argument here in this case is that under these circumstances, the victim reasonably feared a sexual assault.
Yes, there's no question.
Does that not have to then go back and let the jury determine whether or not the evidence warrants it in view of all the ambiguity here?
No, because it's a sufficiency of the evidence inquiry. Is the evidence sufficient, assuming that if you're going to import that as an element under the Lattimore standard, or if you're saying that has all along been an element, that you need to have evidence like that, then the issue is, was it okay to let it go to the jury?
Isn't there a distinction between whether the evidence would support such a finding versus whether the jury made such a finding?
There is, but that's not, the issue here is whether the judge should have directed a verdict based on the evidence, or allowed a motion for required finding under the Lattimore standard. So I would say that you wouldn't need to send that back. There's loads of evidence that the intent was sexual. This was not an intent to rob. This wasn't an intent to ask out on a date or to go out for a cup of coffee. This was an attempt to abduct someone who he referred to as a little girl from off the street in tones that were implicitly sexual. She didn't want to.
How do those tones sound?
Well, you don't have the actual, I don't have the actual recording of the way that it sounded, but they were described as bribing, something morally corrupt.
The victim described it that way.
Victim described it as a high-pitched, sugary, sweet tone. But then after that, in the second encounter, Your Honor, I understand exactly your point with respect to their first encounter. But the second encounter was demanding. He was now angry. He cut through a gas station, parked up on the curb, facing the wrong way on the street, trapped her
Put
between
his
a
arm
wall.
around? He gestured with his arm as if to put it around her.
Yes,
And she
Precisely.
squished up against, scrunched up or
Scooch,
something.
yes, that physical offense piece is certainly present here. And that's important under physically offensive condition, and that's what distinguishes that
Counsel, thank you.
from the first prong. Thank you, Your Honor.
Good morning. My name is Dennis Shedd, and I'm representing Joseph Sullivan. Mr. Sullivan was convicted on the basis of insufficient evidence of a crime that is unconstitutionally vague. Now, the Commonwealth takes the position that sexual conduct isn't required here. It agrees that there was no sexually explicit acts or language involved in this incident, but it says no sexual conduct is required at all. And it reaches that result by breaking the Cahill definite in half. It claims the first half of the
So
Cahill...
if he said, come on, let's make out, then that's the offense, but just get in the car, get in the car, get in the car, that's not an offense. If he
What
said,
hap-
get in the car so we can make out, that would be an offense?
It would be a lot closer to an offense if it annoyed and accosted and was considered offensive and disorderly as well.
Well, I
But
mean,
there's
this is a pretty, based on the facts here, this is a pretty frightening incident of persistent efforts to try to get someone into a car, cutting them off, getting in their face. I mean, I can't think anything more annoying, offensive, and disorderly than that.
Well, I think you could get something a lot
That's
more...
terrifying.
I think it's pure speculation as to whether this was a sexual interest involved at all. Even taking the statement that the Commonwealth points to that Mr. Sullivan supposedly made at the start, that's taken on its own as protected speech and expresses no more than a desire to talk. And even taking into account everything that happened afterwards, it's just pure speculation to assume that what he intended, he had some unexpressed sexual desire. So that alone, I'd say, is insufficient to prove the offensive conduct
But
element.
what else, what other explanation would there be?
He could have been, it could have been a plan to rob. It could have been he's a homeless person who wants to talk to somebody, whether he's willing to or not. I don't know what the intent was, but this evidence here is insufficient to show offensive conduct.
But that's the best alternative explanation you have. He was a homeless person looking for someone to talk to.
That's one possibility, Your Honor, on the evidence here. That's absolutely one possibility. That's all he expressed is a desire to talk. That's all he said, and nothing went beyond that. Now, the Commonwealth
But
takes...
isn't a reasonable fear of a sexual assault sufficient?
No, it's not. No, it's
Really?
not.
If somebody is reasonably fearing that this creepy old man is going to be calling her into a car, that is not a crime?
Well, I'm not sure if it's this crime. Again, it's got to be offensive and disorderly. I'm arguing the disorderly element isn't
But
satisfied
you've
either.
got, as Justice Cordy says, these facts are, a woman is walking down the street near MIT, and
At night?
at night, late, this creepy old man is not only saying to come into the car, but then leaves the car to follow her.
Twice?
Turns around.
That's pretty scary. And wouldn't a reasonable person fear that this person, regardless of what the person truly thought, wouldn't a reasonable woman fear that there was a sexual assault, that was at least a serious risk? I mean, shouldn't the law care about that?
Well, I certainly agree that that's one possibility here, but I don't agree that the evidence here is... I don't think the evidence here establishes enough to prove the sexual conduct. My position has got to be sexually explicit conduct here. The Commonwealth says there has to be no sexual conduct whatsoever. And I think if you look at the intent expressed by the legislature 3 times, it's clear that sexual conduct is required in this case.
Is the evidence here sufficient to support a finding of implicit sexual conduct?
I don't believe it's sufficient to show that either, Your Honor. I don't
Why?
believe even that's sufficient.
Why? Why isn't there enough for implicit sexual conduct?
Because again, all that's been expressed here in the words is just a desire to talk. There's no-
Conduct.
and I agree, he was quite aggressive in the way he expressed that desire. But I don't think that gets over the hurdle and jumps to, you can jump to the conclusion that this was a
Reasonable
sexual
person wouldn't
interest.
understand that as implicitly a demand to come into the car for some sexual encounter? You don't think so?
No, I don't think so. I don't think that's the case here. Now,
Well, let me ask you the same question I asked your brother. Let's assume we're not persuaded by you either. And let's assume that we do find that there must be some sexual conduct, and that a reasonable fear of a sexual assault would be sufficient. Would the evidence not be sufficient to permit a jury to find that on these facts?
I don't believe so, no.
Okay, and let's
I think it's got to be, well,
and put that aside. Even if we say it is, can the case be affirmed because there's no miscarriage of justice, or must it go back to be just so that a jury can make that determination?
well, I think if I think that if, you know, if the judge did not instruct that that was required in this case, and the Commonwealth has taken the position that it's not required. So I think if the court were to say sexually implicit conduct is sufficient, I think that would have to go back to the jury to make that decision.
What
Have
did the
jury
judge-
properly instructed on that point?
What did the judge instruct on the offensive element?
He instructed in accordance with the Cahill definition. Causes displeasure, anger, resentment, especially repugnance, prevailing sense of what is decent or moral. That's the
So
instruction he
is it
gave.
basically the model jury instruction from the district court that's in the Commonwealth's brief?
The model and jury instruction doesn't have that in it, which is...
Well, it does
The
talk
model
about,
jury instruction has that definition of offensive, that is in there, and the judge, and it covers both points. It says it's got to be causing anger, displeasure, resentment, and it's got to be prevailing to the, repugnant to prevailing sense of what's decent or moral. It's got both in the model instruction. The judge instructed in the language of
it's on the
Cahill.
third page of that instruction.
What the judge did omit from the instructions was the annoying, or, you know, the accoster or annoying element. That's another issue I've raised here, is that the statute's unconstitutionally vague and counsel rendered ineffective assistance by failing to move to dismiss. And over 40 years ago, the Supreme Court held that a statute that prohibited people from engaging in conduct that annoys others is unconstitutional because what might be deemed annoying depended entirely on the subjective impressions of whoever happened to be nearby. Now, the accost or annoy element here suffers from exactly the same constitutional flaw because it focuses specifically on the feelings of the other person. It's a completely subjective impression. And I don't believe any narrow construction of this statute is possible. To save this statute, a reasonable person element would have to be added. But a court can't add words to a statute that aren't there. And there are a number of criminal statutes where the legislature has
I thought that
included reasonable person.
Isn't this a reasonable person standard?
No, not on the annoying or accosting element, it isn't, Your Honor. On the, you know, the statute reads,
To prove the fourth element, now maybe I'm gone, to prove the fourth element, the Commonwealth proved beyond a reasonable doubt that the disorderly acts or language would be offensive to a reasonable person in the complainant's position.
right, the disorderly and the offensive are based on, that's a reasonable person. The accoster or annoying, if you look at the words of the statute, it says persons who with offensive, disorderly, or disorderly acts or language accost or annoy persons of the opposite sex. So to determine if it's offensive or disorderly, it's the fact finder who has to make that decision. That's a reasonable person standard. But the accost or annoy has to accost or annoy the person of the opposite sex. There's no reasonable person standard there whatsoever. Does this person consider it accosting or annoying?
Could you just, if the judge gave the model instruction, is that right?
Yes.
Just point me to where it talks about accost or annoy and,
It doesn't, because the model instruction is wrong. It eliminates one element of the statute. The statute includes the words accost or annoying. It's not in the model instruction. The model instruction is wrong. It didn't include that.
so your argument is model instruction is wrong because it doesn't include it and it's a statutory requirement, and because it's a statutory requirement and it is impossibly vague,
Right,
the statute has to go.
exactly. That's it exactly. And my position, again, is as to this element, the statute directs the accosting or annoying specifically at the other person involved here. There's no accommodation for a reasonable person element, so no narrowing construction of this statute is possible. Now, the other point is that not only was there insufficient evidence, in my position, for the jury in this case, but that the jury received incomplete instructions on the elements of the crime. The judge here instructed that the Commonwealth had to prove that Mr. Sullivan engaged in offensive conduct that caused a physically offensive condition. The judge did not tell the jury that the word offensive might have different meanings for those two elements, but in fact it is intended to have two different meanings. Black's Law Dictionary has 3 definitions of offensive conduct. In Cahill, this court adopted the 3rd definition as the appropriate meaning for the offensive conduct element. But if you look at the examples of physically offensive conditions set out in the model penal code and cited by this court in a juvenile, it's the 2nd definition from Black's that's supposed to apply to this element. And that definition is unpleasant or disagreeable to the senses, obnoxious. Now, because the instruction didn't differentiate the meaning of the word offensive in those 2 elements, it essentially rendered one of those 2 elements superfluous. So, and because Mr. Sullivan's conduct was nothing like the examples set forth in the model penal code, setting off stink bombs, strewing garbage, it's likely that the jury would have acquitted Mr. Sullivan had they been informed of the different meanings of the word offensive in those two elements. Now, if I could just backtrack a moment to the first issue, the insufficiency of the evidence argument, I'd just like to point out, again, the legislature 3 times expressed an intent indicating this is supposed to be a sexual offense. First, when the crime was created 100 years ago, it was limited to conduct directed at a person of the opposite sex. 30 years after that, the statute's amended from offensive or disorderly conduct to offensive and disorderly conduct. And then, as the court noted earlier, 10 years ago, it designated this offense as a sexual offense for purposes of SDP proceedings. The Commonwealth's interpretation is also contrary to the common meaning, understanding of the word offensive. There are all sorts of actions that could be deemed disagreeable or causing anger that would not be deemed offensive. For example, if I'm stopped at a red light and I get rear-ended, I'm going to feel displeasure, but it's not an act I'm going to consider offensive. The Commonwealth's interpretation of the statute is also contrary to the way this court has applied Cahill. It ignores the context in which the legislature has used the word offensive in other statutes and this court's interpretation of that word in those statutes. It's contrary to the model jury instruction, which incorporates both parts of the Cahill definition as elements of the crime. So given all that, under Cahill, the other point is that if the Commonwealth were correct, this statute would be unconstitutionally vague, again, because what causes anger or displeasure is an entirely subjective judgment. That there would be, as the court said in the Coates case, absolutely no standard of conduct specified at all. So because there was insufficient evidence in this case, because the jury instructions were flawed, and because the statute is unconstitutional, Mr. Sullivan's conviction should be reversed.
All right, counsel, thank you very much.
Thank you.
We'll take our morning recess.